Hello, my name is Sue Miller, and together with Ed Davis, I head up the Banking and Financial Services Litigation Group at Stephenson Harwood. Welcome to the third in our Autumn 2016 series of 4 short webcasts, in which we take a bite-sized look at some of the key themes emerging in financial disputes over the last 12 months. In today's webcast, Jeremy Livingston, an associate in our Banking and Financial Services Litigation team, will review 2 recent cases in which the English courts have considered the termination and closeout provisions of ISDA Master Agreements.
Hello. This webcast will focus on 2 recent cases in which the English courts have considered the termination and closeout provisions of ISDA Master Agreements. In summary, under an ISDA Master Agreement, following an event of default, there is either an automatic termination or the non-defaulting party can serve a notice designating an early termination date. These closeout provisions are contained in Section 6. The purpose of these provisions is to provide the contractual mechanism for A. calculating the amount due upon the early termination, and B. facilitating the prompt payment of such amount. Following the calculation of the amount due in respect of an early termination, Section 61 requires that amount to be communicated to the party required to pay it by a statement showing in reasonable detail the calculations undertaken and providing details of the account into which payment is to be made. This should be done as soon as reasonably practicable following the occurrence of an early termination date. Section 62 provides that the amount due in respect of an early termination date is payable on the day that notice of the amount payable is effective. In Videocon Global Limited and Videocon Industries Limited against Goldman Sachs International, the Court of Appeal considered whether the defaulting party's obligation to pay the sum due on early termination was conditional on the notice being served as soon as reasonably practicable after the early termination date. By way of background, Videocon Global and Goldman Sachs entered into 2 currency swap transactions under the umbrella of a 1992 Master Agreement, together with a schedule and a credit support annex. On the 23rd of November 2011, Goldman made a margin call under the credit support annex. The margin was not paid, so Goldman delivered a notice of potential event of default dated 28th of November 2011, and then a notice designating an early termination date. This notice designated 2nd of December 2011 as the early termination date, or, if this notice is not effective on such date, the next local business day on which the notice is effective. On the 14th of December, Goldman delivered a calculation statement. Videocon Global did not pay the amount claimed, so Goldman started proceedings in the commercial court and sought summary judgment. Videocon argued that the notice was ineffective because it did not provide reasonable details of Goldman's calculation of the sum due. The schedule to the parties' master agreement specified loss and second method to calculate amounts due. These definitions required, amongst other things, that Goldman A. provide a statement to Videocon showing its calculations in reasonable detail, B. if Goldman determined its loss by reference to market quotations, it should obtain quotations from one or more leading dealers in the market and show in reasonable detail all relevant quotations, and C. determine loss reasonably and in good faith. The judge concluded that whilst Goldman had validly terminated the swap, it had not provided proper details of its calculations. Goldman was therefore granted summary judgment in respect of issues of liability, but was not granted it in respect of the sum set out in the notice. It was, of course, open to Goldman to continue to pursue its original claim to a trial on quantum. However, in March 2014, over 2 years since the early termination date, Goldman elected to simply correct the position by serving a new notice on Videocon, setting out the same sum, but providing the further information required under Section 61. Goldman then reapplied for summary judgment in respect of the sum set out in this notice. Videocon argued that the March 2014 notice had not been provided on or as soon as reasonably practicable following the early termination date as required under Section 61, and therefore, as a result of this delay, Goldman could not claim the sum set out in the notice. The judge disagreed, ruling that the requirement to serve the notice as soon as reasonably practicable was not a condition precedent to the sum due on termination becoming payable. Whilst Goldman might have been in breach of contract for serving the notice late, the notice itself was still valid. Accordingly, Goldman was entitled to be paid, and judgment was given in its favour. Videocon sought to appeal this judgment at the Court of Appeal. Videocon argued that the judge erred in law and misconstrued Section 6D by holding that a failure to serve a Section 6D statement as soon as reasonably practicable merely rendered the statement late and did not render it ineffective. In Videocon's view, the judge ought to have held that a statement which had not been served as soon as reasonably practicable was not effective to constitute a notice required by Section 62, in order for the amount due in respect of any early termination date to be payable. In a unanimous judgment, the Court of Appeal dismissed Videocon's appeal without hearing submissions from Goldman. Importantly, the Court distinguished between a sum becoming due and its becoming payable. As regards the sum becoming due, the Court held that it is clear from the scheme of Section 6 and the definition of loss that the debt obligation in respect of an early termination date arises or accrues due on or as at the early termination date. Accordingly, the accrual of the debt obligation in respect of the amount due in respect of an early termination date necessarily arises prior to the service of the statement referred to in Section 61. Therefore, it cannot possibly be subject to the type of condition precedent that Videocon contended, namely, service of a statement compliant with all of the requirements of Section 61, including the as soon as reasonably practicable requirement. The Court concluded that the debt obligation in respect of the amount due in respect of an early termination date cannot be discharged simply by reason of a failure to serve a statement that is not compliant with all the requirements of Section 61. The Court then considered as at what date the amount due in respect of an early termination date is payable. The Court referred to Section 62, which makes it clear that the amount due will be payable on the day that notice of the amount payable is effective. The Court noted that the clause does not refer to the statement described in Section 61. Rather, it refers merely to notice of the amount payable, a more general term. On its natural reading, the only thing which those words are referring to is what they say, namely notice of the amount payable and not a detailed statement of the relevant calculations and quotations supporting the amount payable. Therefore, all that is required to trigger the payment date for the purposes of Section 62 is the effective giving or service of the notice of the amount payable. Accordingly, in the present case, Goldman's letter dated 14th of December 2011 and delivered on that date clearly set out not only the amount payable, but its calculations of the amount payable. The fact that, according to Videocon, such calculations were not sufficiently detailed to satisfy the contractual requirements of Section 61 did not prevent the letter constituting an adequate notice of the amount payable for the purposes of identifying a payment date under Section 62. The Court added that there was no basis whatsoever for construing the requirement to serve a statement under Section 61 on or as soon as reasonably practicable following the occurrence of an early termination date as imposing a condition precedent of which time is the essence, so that, in the absence of a timely compliance by the non-defaulting party, i.e. Goldman, no payment obligation is ever triggered, and the non-defaulting party is left, as Videocon suggested, to pursue its remedy at common law to establish its loss. This is an extremely important decision, as the Court has effectively ruled that the provision of reasonable details showing the calculation of the sum due on the early termination of transactions subject to the ISDA Master Agreement is not a prerequisite to the sum becoming payable. All that is required is the correct figure. Similarly, the right to payment does not depend upon those details being provided within a reasonable time. Further, 1. The ruling is applicable to both ISDA's 1992 Master Agreement and the 2002 Master Agreement. 2. The Court of Appeal decided that the non-defaulting party only has to give notice of the sum due on early termination and not details of its calculation for the sum to become payable. However, in practice, we expect that counterparties in the derivatives market will continue to deliver just one Section 61 statement containing both payment amount and calculation methodology. This is because the decision does not affect the need to get the calculation right first time. Indeed, if Goldman's second notice had claimed a different sum to that which was contained in its original notice, the original notice would not have set out the amount payable as required by Section 62, and therefore would not have caused that sum to become payable. And finally, 3. Notifying a defaulting party of the correct sum due on early termination means that it is obliged to pay that sum. However, a non-defaulting party's failure to provide, as soon as reasonably practicable, proper details of that sum due will place the non-defaulting party in breach of contract. In most cases, the defaulting party will not be able to prove that it has suffered any loss as a result of this failure, but it is worth noting that there may be cases in which the defaulting party could be able to recover a loss. It therefore remains very important to ensure that the calculation notice is served on time and with sufficient details of the relevant calculations. The second case I'm going to briefly consider is a recent decision of the English High Court in the Lomas and Burlington loan management case. This is the latest instalment in the Lehman waterfall litigation arising out of the collapse of Lehman Brothers. The judgment addresses the interpretation of key provisions in the 1992 and 2002 ISDA Master Agreements concerning interest on sums due following the closeout of transactions upon early termination. By way of context, Lehman Brothers International Europe, the European arm of Lehman Brothers International, has generated a surplus of approximately £7 billion, despite it being 8 years since it went into administration. As a result of this surplus, a number of creditors, perhaps unsurprisingly, are eager to ascertain whether they might be entitled to a share in this surplus. Of particular relevance in these specific proceedings was the question of what interest is payable on debts owed by Lehman following closeout of the ISDA Master Agreement. Section 9H22 of the 2002 Master Agreement provides for interest to be paid on a past due early termination amount at the default rate. The default rate is defined in Section 14. It is worth noting that the default rate may apply both in circumstances where a party is late in paying a closeout amount due under an ISDA and also on any defaulted payments. The court was asked to decide whether this cost of funding was a borrowing cost or whether it could also take into account the higher cost of raising equity. It decided that a party's cost of funding means its cost of borrowing the relevant amount under a loan transaction. This interpretation did not therefore include costs associated with any wider types of funding, such as equity funding. This was particularly significant given that following Lehman's collapse, many banks raised equity at a cost well in excess of the equivalent of 8% simple interest. The judge noted that cost means the transactional costs, i.e., the price which is required to be paid in return for the funding for the period it is required. Such cost is effectively the rate of interest which was incurred, or would have been incurred, by the relevant payee for borrowing the closeout sum over the period during which it remained outstanding at a daily compounding rate. Accordingly, when the ISDA Master Agreement refers to interest, it is referring to interest as the price of borrowing money, and it follows that the cost of funding must be the cost of borrowing the relevant amount. The court was also asked to determine whether the default rate should be calculated by reference to Lehman's original contractual counterparty's cost of funding, or by reference to a third party to whom that original counterparty has transferred its rights pursuant to Section 7 of the 2002 ISDA Master Agreement. In the present case, the parties disagreed as to the identity of the irrelevant payee in the relevant period after an assignment. However, on the basis of general contractual interpretation and general principles of assignment, the court decided that only the original counterparty was the relevant payee. This issue was of significant importance as the Lehman debt, including ISDA claims, have been heavily traded following Lehman's entry into administration. It is now clear that a transferee is entitled to the interest that the transferor could have claimed based on the transferor's cost of borrowing, but not interest based on its own costs. A number of the actions in these waterfall proceedings are currently being appealed at the Court of Appeal and Supreme Court respectively. It is therefore likely that this action will also be appealed, but even if not, it is important for creditors to think about what rate of interest they can certify, and this long judgment sets out detailed guidance on this.